distinct honor to introduce to our Rotary Club my longtime friend, fellow churchman, and classmate, Judge Scott Crichton. Judge Crichton is serving in his 24th year as a judge with the First Judicial District Court here in Caddo Parish, where he has presided over hundreds of jury trials and well over 1,000 hearings and bench trials. Following his baccalaureate studies at LSU and the award of his Juris Doctorate from the Paul M. Averill Law Center, Judge Crichton served as an assistant district attorney for Caddo Parish, maintained a private civil law practice, and served as an adjunct instructor of business law at LSU Shrevary. Following his election to the bench in 1980, he has served on the advisory committee to the Supreme Court on judicial canons, the Louisiana Judicial College Board of Governors, and the Louisiana Supreme Court Committee on Judicial Ethics. He is also the immediate past president of the Louisiana District Judges Association. And if I had had any inkling that my former classmate and study buddy from longer ago than either one of us cares to admit would rise to such prominence, I would have, when I was in his presence sitting together in class, pretended to be much smarter. Judge Crichton is accompanied today by Captain Kenny Sanders, the director of the Caddo Parish Sheriff's Office Regional Training Academy. Captain Sanders has over 30 years of law enforcement experience and has held every position from line deputy to ship commander to senior manager. Prior to his career in law enforcement, Captain Sanders instructed at the university level in a number of engineering disciplines and embarked on graduate studies in industrial management, metallurgy, and educational psychology. He is a nationally recognized expert in security responses to violence against children at school, worshipers in church, and institutional threat assessment. Together, our speakers are going to courageously take on a topic that is just guaranteed to bring people together. The private ownership and use of firearms in self-defense. Their program is entitled Bullet Points on the Second Amendment, Guns, Permits, and Self-Protection. Now, you may recall that last year we had a number of our regular Tuesday meetings fall on dates of some significance. We were blessed last September to hear from the Louisiana State Treasurer, John Kennedy, on the 226th anniversary of the signing of the Constitution of the United States. In December, we met on the 110th anniversary of the Wright brothers' first controlled powered flight, and who present could forget, in November, the meeting on the 150th anniversary of the Gettysburg Address that Jim Henderson so artfully wove in his introduction to Bruce Wilson. Well, my friends, in the fine art of Rotary introductions, when the card you draw is the 14th of January, you're going to have to dig deep. But it's amazing, considering our speakers and their topic, what a surprisingly shiny nugget we can unearth today. You see, on this date, the 14th of January, 375 years ago, the citizens of the Connecticut River colony towns of Windsor, Hartford, and Wethersfield gathered together to decree the fundamental orders. Historians will disagree interminably about whether this simple, single document, published 150 years before the United States Constitution, is really the first written Constitution. What they cannot disagree about, however, is that the concepts it contains, inspired by a powerful sermon preached by the Reverend Thomas Hooker on the text that a foundation of authority is laid in the free consent of the people, appeared for the first time in human history on this date in what is now the state of Connecticut. Without reference to our dread sovereign, our gracious Lord the King, or any other earthly authority, these pioneers found the source of their foundational rights only in their voluntary mutual civil association and flowing from their God. Further, in preamble, they asserted that the purpose of their establishment of government was to maintain peace and union and preserve liberty. What a concept. It seems to be a topic of discussion even today. Ladies and gentlemen, please give a warm Rotary welcome to Judge Scott Crichton and Captain Kenny Sanders.
What a great introduction, and thank you, Jim Graves. Kenny Sanders and I started this program about a year ago, and we really have it designed for about an hour, but we're going to shorten it, you'll be glad to know, and we'll be done by 1 o'clock. But we will cover, of course, the Second Amendment, the text of the Second Amendment. We will cover several United States Supreme Court cases, what took place here in Louisiana about a year or two ago. We will talk about concealed handguns, and we'll talk about self-defense, home protection, protection of yourself, and protection of others. And then at the very end, we will have a test. And, so everybody keep that in mind and pay close attention. The test is actually on the third page of your handout, which everybody should have at your table. Let's get started. This is the Second Amendment, and we'll get started with this. Why I included that, but I just thought, you really can't give a Second Amendment speech without talking about Marshall Dillon and Winslow. But let's move on to the Second Amendment and the text of it. It says this: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The right of the people to keep and bear arms shall not be infringed. We have had a couple of United States Supreme Court cases in the recent several years which are of importance. District of Columbia versus Heller in 2008. And by the way, I'm going to keep the law part of this, the Supreme Court case law, short, okay? I want you to hang in there with me through this, because this is important in terms of where we've been in the last several years and the possible erosion of the Second Amendment, which causes me great concern, and I know it causes you great concern as well. In this case, the District of Columbia enacted a law which effectively prohibited handgun ownership and possession, even in the home, by making it extremely difficult, if not near impossible, to get registration approval. That is, in order to lawfully possess a gun in one's home, as well as a trigger lock requirement for those handguns possessed and kept at home. Mr. Heller challenged the ordinance as unconstitutional and violative of his Second Amendment rights. He challenged the ordinance as unconstitutional, and therefore it went up to through the federal system and ultimately up to the United States Supreme Court. And the United States Supreme Court held properly, they concluded properly, that the Second Amendment confers an individual right to keep and bear arms, and statutes, that is, state laws, or any city ordinances banning handgun possession in the home violates the Second Amendment. All of that is very good, but what is a little bit distressing is the lineup. It was a 5-4 decision by the United States Supreme Court. The conservative contingent on one side, thank God, and then the dissenters on the other. Now, Kagan has replaced Justice Stevens, and Justice Sotomayor has replaced Justice Souter. However, I believe Justice Kagan and Justice Sotomayor are probably of the same ilk, of the same contingent, so I suspect that we still have the different wings of the court on this issue. Now, we had another case in 2010. The city of Chicago this time passed an ordinance which required that all handguns be registered. However, they stopped accepting registrations. How about that? All right, and that was in 1982. So Otis McDonald filed a federal suit against the city, seeking a declaration that the city of Chicago's handgun ban and related ordinances violated his Second Amendment and 14th Amendment rights. The United States Supreme Court held that the Second Amendment right for an individual to keep and bear arms is fully applicable to the states. Again, the shocking part of that, like the shocking part of the 2008 case, was that this was a slim majority that made this ruling. And that led to a debate in this country with regard to our Second Amendment. What would happen, do you think, if the composition of the United States Supreme Court changed, where all of a sudden the group on the left is now the group on the other side, the dissenters? And so therefore, of course, the United States the United States Constitution has a Bill of Rights, which are rights designed for us and civil liberties. States can expand those rights. However, we cannot narrow those rights. And so Louisiana, the state of Louisiana, focused on this issue, as we should be. We presented this to the voters in 2012, and we amended the Louisiana Constitution to make in the Louisiana Constitution a constitutional safeguard for our right to keep and bear arms, just in case something might happen in Washington. And so in November of 2012, this is now in our Constitution, Article 1, Section 11, our own right to keep and bear arms. It says the right of each citizen to keep and bear arms is fundamental and shall not be infringed. Any restriction on this right shall be subject to strict scrutiny. By that, we're talking about strict scrutiny by a court in the event there is an issue with regard to gun ownership. The 2012 Louisiana Constitutional Amendment is critical in that it safeguards our fundamental right to keep and bear arms in the event that the U.S. Supreme Court with a different composition, different justices at a different time, in a subsequent case, revisits that issue, ruling that the Second Amendment applies only to the militia and not to the individual's right to keep and bear arms. It is critical. It is critical for us. So, as I said before, a state constitution can provide greater rights and civil liberties, but cannot restrict those rights or narrow those rights that are granted American citizens by the United States Constitution. Now, we're going to talk about some misconceptions with regard to gun use and concealed handgun permits. I'm going to call on Captain Kenny Sanders, Caddo Sheriff's Office, to talk about that.
As the guy that operates the academy, I get frequent phone calls from people. They want to know what the law says about carrying a handgun. And this week has probably been a world record number of phone calls. It always occurs right after a shooting. Somebody wants to call the academy. And you can talk to a lawyer, you can talk to law enforcement, you know which one's going to be cheaper to talk to. So they'll call the academy right after somebody that's a homeowner shoots a burglar that's trying to make entry into the house, and suddenly they get concerned. We would wish that they'd been concerned all along, but they'll call the academy and they'll say, Captain, that's me, they'll say, Captain, tell us what our rights are as a homeowner to carry a gun inside the home. They also want to know what's their rights as a homeowner to carry a gun inside their car, and then eventually they'll get around to asking us to explain what's their rights as the homeowner just to carry a gun on their own property, in or out of the car. On your table, I've listed the 6 most common misconceptions that I get asked about over the phone down at the academy. Should be a little bitty tiny sheet of paper about a half size and a full size sheet if you'll follow along with me. I need to clear up what may be one of your misconceptions as well. Look at the first, and again, this is a misconception, that I must register my conventional handgun. When I say conventional, I'm talking about what you likely have at home. The one that's on the top shelf of your closet, It's just a regular pistol or a regular long gun. You'd call it a shotgun or a rifle. It would fire one time with each pull of the trigger. It's not a special gun. It'd be a class 3 weapon where you pull the trigger one time and it fires multiple rounds. So if we stick to just conventional handguns, conventional long guns, there never has been a registration requirement in the great state of Louisiana. If you get to other states, that may change. But people frequently call me and they say, where do I go to register my gun? That's only on TV. In Louisiana, there is no registration requirement. You can own practically anything you want to until you get to a class 3 weapon. That's a fully automatic weapon. Now, if you got one of those, you need to keep it real quiet, because yes, there is a registration requirement. And occasionally I'll get people that they inherited one that Papa brought home from the war, and I have to tell them, be real careful, because if you have a class 3 weapon, that's a fully automatic weapon, there is a registration requirement for that. But for what most of us have, shotguns, rifles, hunting guns, pistols, never has been a registration requirement in the state of Louisiana. Let's hope there never is. Number 2, again, this is a misconception. It's illegal for me to carry a handgun inside my car. Current wording of Louisiana law shows that your car is an extension of your home. That sounds kind of wordy, doesn't it? It sounds like it was written by a bunch of legislators. I'm from Rodessa. Let's see, get it down on my level for a minute. That means with your gun, you can do anything in your car that you can do with your gun inside your home. So inside your home, if you keep a gun in your bedside table, then could you keep one in the glove compartment of your car? Well, certainly you can. If you can do it in your home with a gun, you can do it inside your car with a gun. And there's no concealed permit required, contrary to what people are entertaining as ideas. Current law says you can carry a gun in your car any way that you can carry it inside your home. Now, if it'd be illegal to do in your house with a gun, likewise it would be illegal to do in your car with a gun. That one always confuses people, so let me give you an example. Tonight's a late night for me. I got to do another one of these presentations about church security tonight at church. So I won't get home till about 10 o'clock tonight. When I get home with Molly, that's my wife, if she don't have supper ready by the time I walk in the door, I'm going to be one mad captain. So if I take my pistol and I point it at Molly and I say, heifer, where's my supper? Is that illegal to do in my house with a gun? Well, you'll read about me tomorrow in the Times dying at home. But it's illegal in my home, so likewise it would be illegal in my car for me to point a gun at somebody and tell them to move on through the stoplight. So there's where the confusion lies in terms of carrying a gun or hiding a gun inside your home. If it's legal to do at home, in Louisiana, it's legal to do inside your car. Here's the misconception then. People think, well, I got to keep it in my glove box unloaded. That's not what you have to do at home, so that's not what you have to do in your car. So inside your car, you can do anything with a gun that you can do inside your home with a gun. Look at a third misconception. If I carry a handgun in my car, the gun must be hidden and unloaded. That's not what you have to do in your house. You can keep the gun loaded in your house. You can keep the gun hidden in your house. You can keep the gun out in the open. You can leave it lay it on the kitchen table if you want to in your house. So in your home, can you do the exact same thing in your car? Absolutely. Now, if you're going to ride around with a gun on the dash of your car and a nice Caddo deputy pulls you over, it would be extremely wise that you tell us that you've got that gun. We have a tendency to get very aggravated when we walk up on a guy with a gun in the front seat. And please don't touch it while we're standing there talking to you. It makes our blood pressure rise. So even though it's perfectly legal for you to have that gun in your car, please show some due caution by carrying it and don't point it at the wrong people. So is it legal to carry it in your car? Sure. Is it not always the wise thing to leave it laying out in plain view where everybody can see it? Let's agree that there's people that love to break in your car and get it, and there's a lot of law enforcement officers that would get aggravated if you pointed it at them. Look at the next misconception. I must have a concealed handgun permit to carry a handgun inside my car. The concealed permit says you only got to have a permit if you're going to conceal it. There's no permit required for open carry. Open carry means you're just walking around with it on your belt. So right now, underneath this little vest that I got on, I've got a gun underneath my vest. Don't panic, I'm not going to pull it out. If I wasn't law enforcement, simply because I've got it on underneath my vest, it would be concealed. If I was to simply take the vest off, it would be called open carry. There has never been any restriction in the state of Louisiana on open carry. So people can walk anywhere they want to unless there's a sign that says otherwise. They can walk anywhere they want to with a gun in plain view. And there's no permit required. And there's nothing I as the government can do about it because the law doesn't restrict them from doing so. The law says if you're going to hide it, that's when we have a tendency to have a little suspicion. So if you plan on hiding it, there's a permit required. So if you're going to hide it on your person, not your car, remember that's part of your home. And forget your home. You can do anything you want to inside your home. It's your house. It's when you're going to hide it on your person that a permit is required. Come down to number 5 then. I need a permit to keep a handgun inside my home. That's the great thing about the way current law is written in Louisiana. Your home is your castle. You're going to refer to the judge in just a minute. He's going to talk about the castle doctrine. It's your castle. You can do whatever you want to inside your home with a gun as long as you don't violate other laws. There's no permit required to keep a gun inside your home. And a lot of people, right after a shooting like this one we had last week, they call us and they want to know, well, what do I have to do to be legal to carry a gun inside my home? The right answer is, go buy one. Get you one. As law enforcement, we wish everybody had one. But we wish they would learn how to use it. So is there a permit needed to carry one inside your home? Absolutely not. I'm down to number 6 if you're keeping up with me. A handgun's always the best first option for dealing with trouble in and around the home. We wish we could break people from that habit. You know, sometimes guys, when your wife doesn't cook supper, the pistol's not the right thing to pull out. Ladies, when you catch your husband fooling around, the pistol's not the right thing to pull out. When you're mad at your neighbor because they're throwing garbage over the fence, a pistol's not the thing to pull out. But yet in some parts of the country, the pistol seems to be the best first option that people pick. And we wish they would learn to use this before they go to this. So is the pistol the best first option? No, it never has been. Is it a possible first option? Sure. And sometimes it might be the best option and the only option, but it's not always the best first option. Judge?
All right, thank you. Thank you, Captain Sanders. Move forward a little bit and talk about defense. And in Louisiana law, it's referred to as the defense of justification. You've heard the term justifiable homicide. And that emanates from what is in our criminal code with respect to the defense of justification. We'll be talking about self-defense, defense of others, defense of yourself in your home a little bit further, and defense of yourself in your vehicle. The law says that use of force or violence in defense of self, use of force or violence in defense of home, place, business, or motor vehicle is protected. And it is justifiable when committed for the purpose of preventing a forcible offense against the person. Force must be reasonable and apparently necessary to present such offense. There is no duty to retreat. You may stand your ground. We've heard that term a good bit recently. A person who is in a place where he has a right to be shall have no duty to retreat before using force or violence, and he may stand his ground and beat force with force. The stand your ground provisions were added in our justification criminal code laws back in 2006. Louisiana is one of about 20 states that have the stand your ground laws. A judge or jury shall not be permitted to consider the possibility of retreat as a factor in determining whether or not someone lawfully used force in self-defense or in defending his property. So we therefore have a heightened protection for our home, for our place of business, or our vehicle. And there's a presumption that the person lawfully inside had a reasonable belief that use of force or violence is necessary to prevent an unlawful entry. So there are a number of safeguards in the law which protect us as homeowners because of the fact that our home is our castle. And referred to in the law as the castle doctrine. Now,
It's extended to a boat as well. Say you have a houseboat, you're on a lake, or you're going down the river.
it does. It does pertain to self-protection in your boat, just like it extends to protection of yourself
So
in
the
your
same laws
in your
apply.
vehicle. Yes,
You have a gun in your boat, just like you could in your car.
yes. Let me give you two examples here, and this is an example from out of state. This involves well, I'll let you watch it first, and we'll come back to this.
She's been nicknamed the Make My Day Mom, but this is not a Hollywood movie. It was for real for one widowed teen mom. The 18-year-old says she did what she had to do to protect her infant son when two intruders broke into her home on New Year's Eve, and now she is being called a hero. NBC's Tom Chuang has the story.
Home is where you're supposed to feel safe. So when 18-year-old Sarah McKinley heard danger literally knocking at her front door in rural Oklahoma, she grabbed her guns and called 911.
Yes, I've got a few guns in my hand. You said, okay, shoot, you can come to the source. Well, you have to do whatever you can do to protect yourself.
Recently widowed, Sarah had to protect not only herself, but also her 3-month-old son.
If you're trying to get in the door, keep knocking.
With her shotgun loaded, Sarah waited to see if anyone would break in.
I waited for 21 minutes while he busted in my house. And when he did, I shot him, and I had no choice.
The intruder was 24-year-old Justin Martin. Investigators say he was carrying a knife. Authorities also arrested and charged Dustin Stewart for the New Year's Eve attempted burglary.
All right, so let's review the facts. Let's go back to this frame, which is this. We know now that it's a recently widowed young mother at home with infant child on her lap. This is a great textbook example, I think. I like this. Thug, kicking the door open. She calls 911. Now, of course, there's no requirement in the law that we call 911 first. She has the absolute right under Louisiana law to protect herself and protect her infant child and protect her home against this intruder. She shoots the intruder, and she's perfectly within her right to do so. A more recent example
She's been nicknamed
is the following, and this is a local example, happened just a few days ago, about 7 to 8 days ago. 63-year-old grandmother at home, 16-year-old with gun commits aggravated burglary of her home. At gunpoint, the teen forces the grandmother to open her safe, which, in addition to money, coincidentally has a gun in it. The grandmother retrieves the gun, shoots, and kills the teenager.
Now the latest on a deadly home invasion. It turned deadly. What began as a home break-in and armed robbery ended in the death of the alleged attacker in Shreveport's Sunset Acres neighborhood. That was after a 63-year-old woman fatally shot the armed teenage intruder. More details, we go to KTVS News' Aaron Buchanan, and she talked to that homeowner today. And Aaron, the case has brought sadness to both families involved.
Yeah, no doubt about that, Jerry. And that resident, she asked not to be identified, but she's lived in her Morningside Drive home for over 20 years. But her home was also robbed in December, and authorities think the same 16-year-old was involved then. But the resident says her heart goes out to the teen's family.
I don't want them to think that, I just took their son's life because I had a gun. I didn't just do that.
Words from a 63-year-old mother, grandmother, great-grandmother. grieving over the loss of a young man she didn't even know, and who police say tried to rob her at gunpoint Sunday night.
Head pointed at us, I was looking down the barrel of that shotgun.
She chose not to be identified, and we've disguised her voice. She says the 16-year-old, whose name hasn't been released, entered her home on Morningside Drive and demanded money from a safe. She says her immediate concern was for the 2 other family members who were also inside the home.
I didn't even really have time to try to negotiate or talk because the way he was demanding.
She says she opened her safe, grabbed her gun, and fired a single shot. The suspect was hit in the upper body and died later Sunday night at the hospital.
That's not a feeling you want to ever experience because you never know if you're going to live or die.
Guilt, relief, fear, a mix of emotions for a resident who says she was just protecting her family.
Lord, I wish you took another road.
Now, the homeowner's son says his mom will probably put her home on the market soon. Stay.
Now, sad, tragic, but certainly justifiable, completely justifiable in light of our law. And significantly, her words, I wish he had taken another road. I wish he had taken another course. And he chose the wrong course, obviously. But we do another little program in schools regarding teen consequences of misbehavior and law violations. And it's all about taking the right, course. And interestingly, this lady talks about that in her report to Channel 3. And so this is an example of justifiable homicide. And justifiable homicide is a homicide which is committed in self-defense by one who reasonably believes that he or she is in imminent danger of losing her life and receiving bodily injury, and killing is necessary to protect herself from that danger. So it's in our law, and it's completely within the homeowner's right to take that appropriate action because it's imminent, danger is imminent, she fears for her life, and she's entitled to use reasonable force in self-defense. I want to move on in the time we have, because I told you we would be done by 1 o'clock. I do want to point out that you have the right to defend others as well. The threat has to be, imminent. It has to be, and you have to take reasonable precaution, but you can also defend others as well as yourself, and that's allowed for in our law. I want to move to hypothetical number 2. We have 3 here, and let me move to hypothetical 2. It goes like this. It's late at night, and you're asleep in your bed. You hear voices outside. You look outside, and in the driveway, you see a burglar armed with a coat hanger trying to get in your car. You have a brand new laptop inside the car. Would it be justifiable for you to shoot the guy who is armed with a coat hanger? Well, if not, what course of action should you take? All right? Any comments? Well, of course, we need to distinguish here defense of your home when you're inside your home, defense of yourself when you're in your home, defense of yourself when you're in your vehicle. But in this instance, the homeowner is not in the vehicle, and what we're talking about is defense of property. So the answer would be, no, you may not shoot the guy, although you may want to do so. You may not do that. We were speaking to the Women's Republican Club of Shreveport several months ago, and one lady raised her hand to this and said, well, if I can't do it, do you think I could call my brother down the street and shoot him? The answer is still no. I would strongly recommend, as would Captain Sanders, that you call the police, call the sheriff's office, call the Shreveport Police Department. They are there for that purpose, so don't call the brother down the street. Let's go to hypothetical number 3. You're driving home from church, it's dark outside. As you pull into the driveway, you notice that the front door to your house is partially open. A strange truck is parked near the end of your driveway. As you pull up to your home, you see shadows moving around inside. You then retrieve your pistol from under the seat of your car and walk up to your home. As you get nearer to the front of your home, a guy walks out of your front door with your new television set. Let's make it a 50-inch high definition, just bought it from the White Sound Gallery. Mr. Barber fixed you up for the right price. He's stealing your things and you're not happy about it. Can you justifiably shoot the guy stealing your things? Why or why not? And what makes this situation different? Or does it make it different? Well, again, we're talking about he's not in your home, he's not in your car. Is he an imminent threat to your person? What do you have to say about that, Caddo?
It's still stealing stuff. You can only shoot somebody in defense of human life, irregardless of how precious the things are to you. If they're material things, the law clearly says we can only kill a human being in defense of other human beings. You know, I've had to work those cases where these days it's always wheels on cars. I don't understand that. But if people stealing rims off of cars will aggravate a person bad enough to kill another human being, over $1,000 worth of rims. When you look at it that way, that means the price of human life is $1,000. Or some old junky car kills somebody over a car. Or here in northwest Louisiana, squirrel dogs, deer dogs, or duck blinds. They're already armed with a gun because they're out deer hunting, and they're mad because they've been feeding those big fat deer for 6 months. So now they're going to blow a guy out of their deer stand for shooting their pet deer, I guess. All right, killing things or killing people over things is clearly illegal. Yes, ma'am.
Well, what if you get to fight with that guy? Tell him to put your TV down, and he comes to attack you.
So now I'm defending self because he didn't put the TV down. That changes the scenario completely. Now, I got to be able to prove that I'm in defense of human life, and I also got to be able to prove that I'm not the aggressor. Follow me so far? So if I just shoot him because he's running out of the house with my TV, that's clearly illegal. If instead I tell him, leave my TV there and I'm calling the police on you, and he runs at me and says, no, I'm fixing to cut your throat if you call 911, now I get to use up to and including deadly force because I'm protecting myself. Clear it up? Yes, ma'am? No, ma'am. Not only do I get asked that, people comment on it all the time, and they say, why didn't we, law enforcement, just blow the guy's kneecaps off? All right, now think about that for a minute. If I just blow his foot off, how much longer can the guy shoot me? You follow me? If I got to kill a guy, and I'm going to use that as my defense, my justification for killing him, then I better go ahead and shoot him to stop him completely. Yes, sir?
If you really called your wife a heifer, she shot you.
I'm not going to live over it. If I really called her a heifer, what now?
And she shot you, would that be justified?
In Caddo Parish, every judge and lawyer knows me, and they're going to say, Kenny had it coming.
Those are all great questions with the exception of the last one. All right. We promised you that there would be a final test at the end. We're there. And we have 5 minutes to go. And it is, you have a handout on your table. I'm gonna read the question. Carol, tell me, just turn my mic off and we're done. I think we can handle it. Kenny Sanders is going to provide the answers, so don't distress yourself. Number 1, there's no permit needed to keep a gun in my home. And Kenny, you can chime in and as well as everybody here. Number 2, there's no permit needed to conceal a gun in my home. True. Number 3, no permit needed to keep a gun in my car. True. Remember, car, boat is an extension of your home. There's no permit needed to conceal a gun in my car. True. Number 5, if I carry a gun concealed away from home, I must have a permit. True. Any comment on that?
Permits. I get a lot of questions about permits because we're the permit provider for Caddo Parish. You got 2 types of permits as available to you. It just depends upon how much you want to spend to get a permit. If you want to spend a little bit and have a permit for a short period of time, you go down to Caddo Courthouse, be ready to throw down $35, and the sheriff can issue you a permit and fingerprint you at the same time. That permit, though, by Louisiana law, is only good for Caddo Parish and parishes that touch Caddo Parish. It's not good in Texas, not good in Arkansas, certainly not good in Mississippi. So it's only good for Caddo Parish and those parishes that touch Caddo Parish. It's only going to run you about $35. You're going to be tied up for less than half an hour to get it. On the other hand, you want the big permit, you got to come to class to get it. It's a one-day class. It's going to cost you $100 to pay the sheriff to get it. It's going to cost you $125 to pay the state police for the actual permit. So total cost $225. It's good for 5 years. There is a shooting requirement. You got to demonstrate to us you know how to use the pistol. I wish, from a law enforcement standpoint, absolutely everybody had one. The guy that asked, does it extend to a car and a boat? My wife's got one. My daughter that's in law school's got one because she knows she's hanging out with some thugs at law school. They're taught in the school. Somebody tries to beat in your car door and you're inside the car. Current Louisiana law says you can shoot them outside the car. That stuff that Daddy used to tell you about you had to drag them in, that's not what law says. Law says shoot them outside, leave them laying there. Call 911. It's fine if we find them on the grass dead. The law says you can do it that way.
Number 5, all guns in Louisiana must be registered. False. Number 7, if someone is trying to break in my home and I'm afraid they will kill me, I can use deadly force to protect myself and my family. True. Number 8, if someone is stealing my lawnmower, I can use deadly force to stop them. False. Distinguish property from person and from imminent peril of danger. Number 9, if someone is carjacking me, I can use deadly force to protect myself and my family in the car. True. Number 10, I can use deadly force to keep someone from stealing my car. False. Number 11, I can threaten someone with deadly force to make them get out of my deer stand or duck line. Captain Sanders, comments?
The threatening part. Let's distinguish the threatening versus the pulling the trigger. Let's also distinguish duck lines, deer stands, and deer and squirrel. They're still just wildlife. They're animals. They're not human life. When it comes down to threatening somebody, the threat alone is a violation of law. When it comes down to shooting somebody out of your duck line, we call that a degradation of homicide in the state of Louisiana. You're going to go to a penitentiary if you get the wrong or the right judge. He's not going to have much choice but to lock you away for a while.
Notwithstanding the fact that deer stands and duck lines are very important. Number 12, I can automatically carry my pistol concealed at church once I get my permit. False. Number 13, any comment on that?
The church requirement, that law was adjusted to show that if you decide you're going to carry at church and your church wants to develop a security team, you must A, have a state concealed permit. B, you got to get the training. We provide the training. The training takes about 16 hours initially to get it. Then the church has to make the decision as to who can pack heat in church. Just because your permit is valid does not give you the authority to carry a pistol in church. It has to be a church decision.
Jim Graves and I are on a security committee at our church, and our Pastor Austin Johnson is president. We're studying this issue now, but there is special protocol that must take place that Captain Sanders has just discussed. Where am I? Number 13? Number 13, once I get my permit, I can carry my pistol concealed at bars. False. There's a special rule on that. Number 14, guns are great defensive tools, but I must be aware of collateral damage. Absolutely true. You must be aware of collateral damage. The bullet may travel, and there may be unintended consequences. Number 15, to be justified in using deadly force, the threat must be imminent. That's true. An immediate threat. Number 16, a person running away from me would not be an imminent threat to me. True. Number 17, it's illegal for me to shoot a person outside my home simply stealing items from my yard. True. Number 18, it's illegal for me to shoot a person for stealing my best hunting dog. We're having trouble with this one, aren't we? We have to really focus in and deliberate on this one. is true. Number 19, it's legal for me to kill someone that's trying to break my home and hurt my family. True. Number 20, if I live in Louisiana, my concealed carry permit must be issued in Louisiana. True. A concealed carry permit issued in Louisiana is valid in many other states. That's true. Any comment on that, Captain Sanders?
Law changed last year. For those of you that may be permit holders, the law was adjusted last year to say if you reside in Louisiana, you must have a Louisiana permit. For years, everybody was going and getting Florida permits because Florida was convincing everybody that their permits were valid in more states than Louisiana permits. The law was adjusted to say if your driver's license says you're a Louisiana resident, then you must have a Louisiana permit. Call the academy, we'll work you out getting in a class, and we'll give you a valid Louisiana permit, and then you're good for 5 years.
Number 22, concealed carry permit is only valid for 2 years. That's false. It is actually 5 years. Number 23, if I have a history of drug abuse, alcohol abuse, or mental illness, I can't get a concealed carry permit. True. Any comment on that?
When you turn in your paperwork to get your state permit, there's one question at the bottom of the permit questionnaire. They're just going to ask you, have you got a history of drug abuse, alcohol abuse? Have you ever been deemed mentally incompetent? I don't know how they're going to figure out have you ever been deemed crazy. But if you answer no, you don't have a history of that, then you simply get a permit. So the name of the game is say, yeah, you're sane.
Number 24, a background check will be performed before I can obtain my concealed carry permit. That is true. And let me say this, Captain Sanders devised this big final test. The last question is Judge Crichton is running for the Supreme Court, and he has my vote. You be the judge of that. Thank you.